Call the Board of Equalization meeting to order. I'll call on Commissioner Adcock to lead us in a moment of silent reflection and the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Ask for a motion upon the review and approve the agenda. Second motion and a second. All those in favor indicate by saying aye.
Aye.
Opposed? Motion carried. So we're now starting the 2022 County Board of Equalization hearings and call on Shannon Rittberger.
Hey, good morning, Commission. Shannon Rittberger, Director of Equalization. I should probably say something about our schedule since I've been asked a couple of times already. So today we're doing exempt properties. You're going to make a decision on these for those that you deny an exemption on. They have the right in statute to come back 7 days later. So we could hear from somebody on the 20th or 22nd. Not sure what we're going to do. So we do the exempt property today. Tomorrow we have a morning's worth of regular assessment appeals. And we have got most of the day on the 20th scheduled. Deb isn't sure if we'll need to go beyond the 20th. I think we'll probably have to go into the 22nd, but if we do, that'll be a short day. And we've got those days at the end of the month, 27th or 29th or something like that. I seriously doubt we'll need those. Our appraisers are working with property owners. They're looking at properties. It takes a while for us to get out and look at them and see if there's some bad information we've got, if there's a reason that the property is overassessed or not, and then the property owner has to decide whether they want to appear before this board or not. And at this time of year, we're always pushing to get all of those properties looked at and get the property owner to tell us, do you want to appear before the board or not? We don't want to just schedule them an appointment and then we find out the day before that they're not even coming in. Well, that'd be a waste of time. So that's where we're at. We might, I think we'll probably use part of the 22nd. Today we're doing exempt properties, but we're going to start with what we call omits. So omits are property that was omitted from the tax roll. We mailed out assessment notices, and then after we mailed out assessment notices, we found some property that wasn't on the tax roll, so we bring it to you to say, adjust the value of these parcels to account for the property that was not on the tax roll. And we've got 4 of them. And I'll give you a quick explanation. They're really very simple. Jim and Pamela Tiltram is a property that was split. And I don't know the details, but we had a tract of land with buildings on it. And when they split that tract into 2 pieces, we dropped a building or some of the buildings off. And that was a mistake on our part. So we had a value for buildings that we dropped off the tax roll that we're asking the commission to put back on. And property owner is aware of that. That fixes a mistake when we created those new parcels and dropped the buildings. The other 3 are the same situation. It's Octagon Towers. We had a property owner who has a cell phone tower on his property, and he contacted us and said that tower is not on the tax roll. Now, a lot of those towers like that are state assessed utilities, and they are on the tax roll, they're just not locally assessed. This tower doesn't, its ownership requires that it be locally assessed and not state. And it wasn't state assessed. It went a couple of years not on the tax roll. We figured out who owns that tower. We contacted them and we told them we're gonna put it on the tax roll at this value. And then we found out they got 2 other towers. They told us that they had 2 other towers in the county. So we're actually adding 2 or 3 cell phone towers, asking you to add 3 cell phone towers to the tax roll, and property owners aware.
So Shannon, how does that happen that those towers get built? They don't have to come to the county for anything they don't have to come for a permit of any kind?
Oh, the towers have been there for quite a few years.
Okay,
But they, at one time, they were owned by Verizon, and when they're owned by Verizon, that's a state-assessed utility. They transferred ownership. A company bought these towers and a bunch of towers across the country from Verizon. The company that owns them now is not a state-assessed utility. So there was 1-2 years or something like that, because we didn't know they sold. Well, when Verizon sold them, then technically they're not on the state-assessed utilities tax roll. And they should have been here locally. We just now found out that somebody else owns them.
okay.
It's sort of difficult with those because it's not like they record a deed when they buy a cell phone tower. So we have to find out some other way that they sold.
Okay, thank you.
It was, it's very nice of the company that bought them to tell us, okay, but we own 2 others as well.
Do we have other towers that are owned like that in the county too? That
Yes,
okay,
yep, that's right.
Okay.
It depends on the ownership. If Verizon owns a cell phone tower, it's a state-assessed utility. If you own a cell phone tower, you're not a state-assessed utility. We'll put it on the tax roll here.
interesting. Okay,
The state-assessed utility, Verizon will pay taxes on all of the company's assets in the county based on the gross receipts of Verizon. If the tower is locally assessed, you pay taxes based on the value of the property. A railroad is a state-assessed utility. Power companies are state-assessed utilities. We know what buildings they have, but they don't pay. They don't get an assessment notice with the value of that building on it. They pay taxes based on the gross receipts of the entire company.
okay.
Also known as pilot, payment in lieu of taxes.
No, that's
Different?
federal property. There's federal property in Pennington County. The government will give the county money, payment in lieu of taxes. This is the railroad. The railroad pays taxes based on the gross receipts of the entire company, distributed based on how much track they got in each county.
So Pennington County Housing Redevelopment, we pay using
Payment
a
in lieu
pilot
of
program.
taxes. Yep. Okay, so that's a little bit different. It's a law specific to them, based on the housing, and it has to do with their income. And there's a formula that comes up with
It's
that
5
tax.
times gross, or 5% of gross. That's how they figure
Yeah, something like that. And we get a letter from them that says, this is what it is. We get that every year. They're sort of the only one that does that.
So how do you, I understand you can value the land that the tower's on, but how do you determine what the value of the tower is? You just try to get a cost estimate?
Yes.
Because they're not gonna tell you what they sold for, so you can't really do a market approach.
Well, this company actually did tell us what they sold for, but they bought like 50 of them across the country. So it's not really a very good sale that we can use. Yeah, it's a cost approach. We use Marshall and Swift and estimate what that tower would cost to build and subtract some depreciation. We've let the property owner know what the value we're adding it at. We could also do an income approach, but then we'd have to know how much rent they're getting for whatever's hanging on that tower, and we just use a cost approach.
But if somebody buys a tower, is that tower on leased land or is that a fee simple ownership?
I think all of the towers that we have are on leased land.
That's why you don't see the transfer.
Yes. Yep. Yeah, we don't get a deed. Yep. Yeah, I mean, I think there should be a deed. It's usually some kind of a purchase agreement between the two parties, and that doesn't get recorded here.
Not recorded with the county at all, huh?
No, well, I've seen some of them. We have buildings on lease sites that are the same issue, hangars out at the city-owned airport. Occasionally, we'll see something come through, but most of the time, no. If I were to buy something like that, I'd record it. Recording it puts it on public notice that I now own this. But most people don't do that.
Okay.
Mr. Chair.
Other questions on these? Commissioner LaCroix?
So Shannon, on this first part, you got the omits, the exempts, 100% and partial exempts. Are you looking for a motion on each one separately? Or are you want to wait until after you get through the?
I would suggest that you deal with the omitted property. Let's do that. And then when we get into the exempts, I'll explain the process of how a property becomes exempt and the different spreadsheets that we give you and get into that. And we'll do each of those spreadsheets maybe, but deal with the omitted property here first.
Okay. You looking for a motion for approval?
Yes.
Move for approval.
Second.
Got a motion and a second to approve. So this is on the Tiltram? Is that what's-
On all four, right?
Are you talking all four, or are we talking?
I don't know why not do all four of them at
We
once.
do all four? Okay, is that your motion then?
Yes, sir.
Okay. I presume you're agreeable with that, Commissioner Roskinek. So any further discussion on these?
We have people that are speaking on this?
Not on this, no.
Okay, I didn't
No.
know if we were on any of these, okay.
Yeah, and as Deb points out, if they were to have a problem, they can come back. But we've already contacted them and they know they're not coming.
Okay,
Okay.
okay. So all those in favor of the motion indicate by saying aye.
Aye.
Opposed? Motion carried.
Okay, now let's do the exempt property. So any property that is exempt from property tax has to make an application to my office by November 1st. My office reviews the property and makes a recommendation to the Board of Equalization. Every property that applies for an exemption gets printed in the newspaper, so the public knows who is looking for an exemption from property taxes. That's been printed, that's done. Then the Board of Equalization takes these applications and my recommendation, and it either approves or denies them. The decision ultimately is the Board of Equalization's on whether a property is exempt from property tax or not. Now, there are state statutes that set up the criteria for whether a property can be exempt from property taxes or not. A lot of people think that a nonprofit organization is by default exempt from property taxes, and that's not true. There is a state statute for religious organizations that says the property has to be owned by and used for and defines what a religious organization is. There's another statute for charities, benevolent organizations, schools. There's a state statute that sets out the criteria of whether a property can be exempt or not. That applicant makes an application, it comes before the board, and this is what you're doing right now. You're going to approve or deny them. Now, what we do here is we create several spreadsheets because we've got so many of them. The first spreadsheet is new exempts. So we split out all of the properties that are asking for an exemption that are brand new this year. Now, some of these organizations are not brand new, like Monument Health. That's the hospital here in Rapid City. But this is a new property that the hospital is requesting an exemption for. And we just split these out as new properties, just so you know what ones are asking for an exemption that haven't in the past. That's the only reason we split it out that way. Then we have partial exempts and 100% exempts. Those are all properties that have been exempt in the past, but they still have to make application and request an exemption again this year. We split them between those properties that are only partially exempt and those that are 100% exempt, just so you know that. That's the only reason for the two different spreadsheets there. Otherwise, they have been exempt in the past, and they're asking for it again. Of those three, the new, the partial, and the 100%, I recommend that you grant the exemption on all of those. They qualify under the state statutes, and I think you should grant all of them an exemption. The last one is, the spreadsheet's titled Exempts Denied. It's technically not denied. You have to take action on that. But those are the ones that I recommend that you deny because they do not meet the criteria of the state statute. So maybe a suggestion is that you act on, unless you have a question on one of the properties of the new, partial, or 100%, unless you have a question, just act on all of those. I suggest you grant the exemption. And then the properties that I recommend denial, all or most of those property owners are here, and they'd like to say something. And I have some notes on why I think they don't qualify, and we can do each of those individually.
Mr. Chair,
Commissioner Roskinek.
I'll make the motion that we grant exemptions on the 100%, the partial, and the new.
Got a motion, is there a second?
Second.
Any further discussion on these three, the new exempts, the partial exempts, and the 100% exempts? Hearing none, all those in favor of the motion indicate by saying aye.
Aye.
Opposed? Motion passed.
Okay, so on those that I recommend denial, let's go down through those one at a time. And on that spreadsheet, the first one is Black Hills Cave and Nature Conservancy. It's listed 3 times. That's just because there's 3 parcels, but it's one property, same argument all the way down. Is somebody here from the cave? I want to check outside to make sure.
Okay?
Deb, do we have any paperwork on these denials?
I didn't see any. Shannon, do you have paperwork on this? The cave,
Oh, you have additional besides the spreadsheet?
right?
No, I've just got my notes, and you'll hear from the property owner. Well, the property owner isn't here. What, you're Magpie? Okay. Your economic development. Okay. All right. So nobody is here for the cave. So I will go down through my notes. I'll tell you what it is. And when we're done with this, I'm going to contact each one of these and say, because the law says they can come back if they want, even though he's here today, the law says he can come back 7 days from now. So I'm going to contact each one of these, and I will I'll do my best to try to get a response from the cave and tell them they can come back.
What is the cave?
Okay, so the cave, it's a cave property. The property is a nonprofit corporation, Black Hills Cave and Nature Conservancy. And they purchased a cave property west of Canyon Lake. They purchased it from a private landowner for the whole purpose of protecting the cave and the natural resources of the cave. So they acquired it in May of 2020. They're requesting an exemption under a charitable statute. I think their comments lead towards the benevolent statute. But this is what they say. The purpose for which the corporation is organized is for conservation, restoration, and preservation of cave and carrot resources, scientific study and public education of biology, geology, and cartography in relation to cave resources, and protection of cave and carrot resources to support surface and groundwater resources. So they bought this property for that purpose. And I think the corporation was formed by members of some caving club here in the Black Hills. Okay, I think that's who got together and bought this. And it was for the whole purpose of just protecting the cave. Now, the reason I say that they don't qualify for an exemption, and I guess I can give you a copy of the statute.
So Shannon, can I ask you a question? Under that name then, Black Hills Cave and Nature Conservancy, I understand you have the legal descriptions here, but do they have any other properties outside of this?
No.
Under that name?
No.
Okay,
No, this is it.
okay.
Mr. Chair,
Commissioner Ross, can I?
Shannon, how many acres would all this add up to?
We'll look them up.
Okay.
Can it be used for, they can exempt for education?
No, because the statute that grants the exemption for education describes a school, but the one specific point says it has to be accredited by South Dakota Department of Education. So, no, would not be a school. On that one point, at least.
Okay.
They asked for a charitable exemption, but then on their application, they make comments that reference the benevolent statute that I just gave you, okay? So, they're a nonprofit organization, and I think they have a admirable goal here, but the statute, I just gave you a copy, says the property must be owned by a benevolent organization defined as any lodge, patriotic organization, memorial association, educational association, cemetery association, or similar. And I don't think they're any one of those. The statute says the property must be used for a benevolent purpose, and that's defined as an activity that serves the poor, distressed, or underprivileged, promotes the physical or mental welfare of youths or disadvantaged individuals, or relieves a government burden. And although what they're doing is cool, it's not a benevolent or charitable use as defined in the state statute. The organization is not a benevolent organization as defined, and the use doesn't match the statute. So I don't think they qualify. 46 acres. 46 acres in 3 parcels.
They don't qualify as ag or anything?
There's no ag use of the property.
They don't have any cattle, nothing like that on this land?
So this cave previously was used as a tourist place, is that?
No, I don't think this ever was. This is not one of those that we would recognize.
So,
Although those that we recognize as tourist places, they're all privately owned. This one just isn't one of those, it's another one.
Mr. Chair, So did this property just recently sell in the last couple of years?
They purchased it in May of 2020.
Okay. I think you get to it off of Cleghorn Canyon.
Yes. It's either Cleghorn or Dark Canyon. I can't remember which.
We did the appraisal.
On this one?
Yeah.
There's actually been several caves that have sold in the last 10 years.
Well, this one, just on private property.
All of them. Several caves in
And
the Black
it
Hills have
was
sold.
never used commercially. It was more just for this club that probably purchased it.
I think the club had been in and out of this cave for many years. And I don't know, I'm guessing this, but that they were probably looking to the future and didn't want, if that property owner sold, it go to somebody else, so.
Mr. Chair,
Commissioner LaCroix?
are they a 501c?
They are,
They are.
yep.
So
So when we look at all of these statutes that grant exemption, we'll find something common in all of them. They all say you've got to be a 501c3 nonprofit, okay? But not every 501c3 nonprofit is exempt, all right? But it has to be a 501c3 nonprofit. It has to be owned by a exempt entity, benevolent, charitable, school, whatever. And it has to be used for that exempt purpose, benevolent, charitable, school, whatever. We'll find those three in all of these statutes. Has to be a nonprofit, has to be owned by the organization, and used for the exempt purpose.
So if we were to deny today, that'd give them a chance to come back.
The law, even if they are here, the law says that they have the opportunity to come back 7 days later.
And have you guys had conversations with them already?
I've talked to an attorney representing the property, who I think is one of the corporate owners as well. And when we're done here, I will contact all of them again and say, if you would like to come back, this will be the day and time.
Because I'm leaning towards denial today to have them, give them the opportunity to come back and tell us what their plans are with the property.
Yeah. I think regardless, the law says they've got 7 days to come back. So Magpie Creative is another one. He's sitting here. He'll want to speak before you. The law still says he has the opportunity to come back 7 days later. So,
But the Black Hills Cave people were aware that this was on the agenda for
Yes.
this morning. Okay.
yep.
Mr. Chair.
Commissioner Roskinek?
So then you've talked to these folks and you've explained to them the reason for your recommendation for denial, and they understand?
Yes.
Okay,
Well, I've explained it to them.
okay.
And I think they understand.
Mr. Chairman,
Commissioner Laster?
refresh my memory again, Shannon. What's the minimum acreage for ag land exemption?
In Pennington County, it's 40.
And this doesn't qualify at 46 acres because you still
There's
have to,
no ag use of the property.
you have to have 40 acres plus some ag use on it regardless.
No, the backwards. So the law says the principal use of the property must be ag production for intended profit, and then either 40 acres or an income. So the first thing that has to be met is the principal use of the property is ag production.
Mr. Chair,
Commissioner LaCroix?
I'd make the motion to uphold the denial on Black Hills Cave and Nature Conservative on both of those.
I have a motion. Is there a second?
Second.
Holding the denial. So I have a motion and a second. Is there further discussion? All those in favor of the motion to deny, indicate by saying aye.
Aye.
Opposed? Motion carried.
The next one on the list is Magpie Creative. We've got 2 parcels there, and this organization is asking for an exemption as a charitable organization, and I'll give you the statute that defines that.
Mr. Chair,
Commissioner LaCroix?
I think I made a mistake. I said the 2, there was 3 for Black Hills Cave and
Okay.
Nature Conservancy. I meant all 3.
Okay, I agree.
You got it corrected?
Yep,
Okay.
got it. Thank you.
Did you catch that?
I had 3.
Okay, Magpie Creative is here, and I've been out to look at the property, and I think I talked to you there, right? All right, I'm sorry. It's okay. So Magpie, well, I should say Racing Magpie is the business name for Magpie Creative. So evidently they started something and then changed their business name. Um, But regardless, we're looking at the property. They are a 50, is it a 503 or 501?
Or 501c3.
501. I got a typo on my paper here. So it's 501c3, so they're a nonprofit. There's two parts to this property. The main property is used as an art gallery for native artists and art studios. The adjacent property is currently rented to a private school and a couple of artists. The purpose, and I'll say this briefly, but then he can expand on that. The purpose is to elevate and amplify native and other artists through education, cultural, and research programs. Okay? The funds for Magpie come mostly from government grants and some private donations. They're a nonprofit organization. The statute for a charitable organization defines a public charity as any organization or society which devotes its resources to the relief of the poor, distressed, or underprivileged, and it must lessen a government burden by providing its services to people who would otherwise use government services. It defines a charity, okay? And I don't think this organization and the use of the property, although noble, I don't think it is a charity. I don't think they meet the definition of charity in state statute.
Chairman, so
Commissioner Acker.
it says a public charity will receive a majority of its revenue from public funds. Isn't government grants public funds?
Yes, I don't argue that they're not a nonprofit
Right,
and that their funding is appropriate.
right.
I don't think that their organization, regardless of that, and the use of the property meets the definition of a charity here. Devotes its resources to the relief of the poor, must lessen a government burden, kind of a thing.
But that's what qualifies it for exempt, right?
Yes. I don't think they are a charity. I'll agree they're a nonprofit.
Well, it says also, though, for one of the criteria, that public funds are used to basically fund it, to make it exempt. Isn't that one of the,
That's one of the criteria in the statute, yes.
Right.
And
so you need 5?
I don't know, I guess we'd have to break down that statute.
That's what I said. So if you use at least one of those for the purpose for exempt, doesn't it qualify?
No, you got to meet all of the criteria in the statute. As I said in the beginning, all of these statutes require these organizations to be nonprofit.
Which they are,
Yeah, but not every nonprofit is exempt from property taxes.
right, but they qualify for some of what are some of the definition.
Yeah, they are a nonprofit, yes. They receive government funds, yes. But they don't devote their resources to the relief of the poor, distressed, or underprivileged, and they don't lessen a government burden. They're not a charity.
So basically, artists and people that work in this as a school they are not charitable because they are getting charity. And they are charitable by giving government grants in order for these people to be able to do what they're doing in this place. So,
I think you're making his argument for him.
well, I've seen it. I haven't went in it, but my husband also has worked on some of their properties. So if I believe that it wasn't that, and I haven't, heard from the horse's mouth, which my husband, they do some really good things that are, I believe, should be tax exempt. That's my opinion. Okay.
Mr. Chair,
Commissioner Oskinen.
so Shannon, what would the assessed value be if they weren't exempt, just out of curiosity?
We'll look that up. I don't have a printout of that. There's 2 parcels.
Are these both located in Rapid City?
Yes.
Off of St. Pat?
Off of St. Pat,
Okay.
yeah. 192,000 plus the other parcel.
Right.
Mr. Chair, you done?
Commissioner, correct.
$305,300. So about $500,000 between the two properties.
I just wanted to say that I just took a trip to Pine Ridge earlier last week and visited the new art building down there, and took a tour and listened to some of the intake of what is happening on Pine Ridge, and I'm glad that this is part of it, because they're doing the same thing, creating space for the artists to be able to do their work and promote it, and I think this is the same concept of what's happening. So, we can, I respect Shannon, but I respectfully disagree with him on this one. I would go with it's tax exempt for the services that they're providing. I think they are providing a service that is helping our Native community to prosper. And I think it's just how you decide to look at it.
I'd like to hear from the gentleman that's here. Can you please identify yourself? And
Yes, sir. My name's Peter Strong. I'm director and a board member of Racing Magpie. We did change our name from Magpie Creative. That's the two names. I do have a few notes prepared, but I think you did you touched on a lot of the points here. So I'll just skim them and share. But I do want to say that I really focused on that clause in the state code that said that we provide resources to the relief of the poor, distressed, or underprivileged, and that sounded like the concern that Mr. Rittberger had. And I just found some statistics about the Native community that we support, and Native artists specifically. And that more than 53% of Native folks in Pennington County live under the poverty line. And we do serve most of western South Dakota, and most of the other counties are at 40 to 50% as well. In a study by First Peoples Fund, a national organization that serves Native artists and communities, and it's based here in Rapid City, they found that 30% of all Native people are practicing or potential artists, and most live below the poverty line. Almost 40% of reservation households rely on arts-based income to live, and in that study, 61% of the artists interviewed had an annual household income under $10,000. And all of our programs are free to participate in, or have an extreme sliding scale to meet people where they are, because that is the demographics of our community. And I'm skipping through this because I feel like you all know a lot of it. I know for the distressed piece, one of the things we did is we doubled down on our commitment to supporting Native creative community by pivoting to free virtual programming. So we had all kinds of stuff over the last 2 years that tried to reach people in their homes and keep them safe. And we also were asked to partner with some regional organizations, and we distributed some 40,000 in relief funds to Native artists in western South Dakota, $500 to $2,000 each, just to support them, because 95% of artists across the country lost their some portion of their creative income as everything shut down. And then as far as what we do, that same study mentioned that there are 6 areas that are needed to support Native artists to succeed and to begin to move towards culturally specific success. And those are access to markets, access to supplies, access to credit and capital, access to business knowledge, access to informal social networks, and access to space. And the study found that supporting those 6 areas can support Native families and economic development by increasing leadership and capacity, increasing assets and wealth among low-income individuals and families, altering the underlying causes of poverty and enhancing capacity for long-term sustainability. And in our programs, we meet almost all of those 6 things ourselves: space, market, social networks, and business knowledge. And what we don't, we try and bring in partners to support that work, to reach those artists.
So, Mr. Strong?
Yes, sir.
Do you charge for those services then, in addition to those individuals that you're providing those services to?
The only thing we charge for is we do have heavily subsidized studio rentals in the buildings, and we keep those really affordable, but it's important for folks to rent and have that part of their business process. Everything else is free, or if we rent out some space and a community organization or a group of people want to do an art class and they can afford $20 or $5, we work with them to rent the space at whatever they can afford. So that's that sliding scale we operate on.
Okay, thank you.
Mr. Strong, you have 2 buildings. Can you describe in each building, what you do in each of those buildings
I can.
and what's in those?
Absolutely. So the other building, 801, when we purchased these last February, we renovated 801 completely. And in that building, we have a gallery upstairs, 2 artist studios, art offices, and then downstairs we have 2 more artist studios and common space underneath for all these other creative things. The other building, we did not do any renovation to. I'm currently renting it to some musicians who don't mind the mess in there, but they're renting a portion of it. And then a Montessori classroom needed to rent the front part just for 1 school year, and they're just renting it for now while they find new space. And the rest of it is unused at the moment. And the whole part of the value of this space to us is we can plan for the future and expand and grow over time.
I'm sorry, tell me again, who's renting that for 1 to 2 years? Is that what I understood you to say?
It's called Children's House Montessori, and their upper elementary classroom they had a rental lined up and it fell through at the last minute. And they asked to rent our space just for 1 school
Okay.
year, and they'll be out in May.
Okay.
Mr. Chairman,
Commissioner Lassiter?
I have a couple of questions. I walked through what Shannon mentioned down here, and I see that, and this is in the 10.4, 9.1, you shall receive a majority of your revenue. I think you showed that. You shall offer services to people regardless of their ability to pay. So my question on that is, for those studios, if someone can't pay but they need to utilize those studios, would you still let them utilize them for free if they couldn't pay for them?
We do enter, the short answer is yes. The longer answer is we do enter into leases with them for those heavily subsidized spaces, and we have a really flexible policy to work with them because the arts revenue is so fluctuating. We work with them. I actually have 2 of my 5 artists are a little behind right now, and we work with them and find other ways to cover their rent.
Gotcha. I also see that you shall be recognized as an exempt organization under 501c3. It sounds like that. The other one that I have a question about is shall lessen a governmental burden by providing its services to help to people who would otherwise use governmental services. What services are you reducing the use of? I mean, I run a nonprofit and it's a pregnancy center. Everyone on the board knows. So there's programs that we do that obviously we can show that. What can you show that you reduce to the government burden?
Well, I think the connection for us is that we're supporting Native artists to become independent business owners, to be able to support themselves by selling their artwork or teaching the skills and the cultural knowledge that they have in the world. So we don't track direct connection to government, to programs that they're involved in, but that's the idea, is that if we can support them as business people and build the community, that there's a gradual increase in monetary wealth and then a gradual decrease in reliance on government programs. And there are some moments like that pandemic relief that we distributed where we know that those folks that we distributed to were right on that verge of needing to go on government assistance during the pandemic. And those funds helped them move forward and not relying on government funds.
And Mr. Chairman, if I may ask the last one, if I understood correctly, one building is the gallery and the studios and the common space currently. The second building, you're renting it out to musicians, a Montessori class, or the stuff is unused for the ministry. Is that correct? Or your organization, is that correct?
Yeah, that's a good summary, yeah.
Mr. Chair.
Commissioner LaCroix.
I'm going to make a motion, then request the floor afterwards if I get a second. I would move approval of tax exempt for Magpie Creative on their 37904 and 37901 properties.
Is there a second?
I'll second that.
Got a motion and a second. Further discussion?
Thank you. Mr. Chair, you know, the reason why I made this motion is because I think after doing the cultural tour of Pine Ridge last week and seeing how important the art is to the Native community and economic development, and listening to at that art gallery what is all happening, I think it's important part of their culture that I think we need to support. I mean, it may not be recognized in some other form as far as our properties and stuff, but in all reality, it is part of bringing back their culture, the Native American culture, and also economic development that is the biggest part of it. And I think Travis did a good job of going through it and showing that I think you are doing what you're saying you're doing, and I believe it should be tax exempt.
Mr. Chairman.
Commissioner Laster.
Let me interrupt. You mentioned one parcel. There's two parcels.
Yeah,
there.
I did 01 and 04. I did 379, 04, and 01.
Okay.
I just did.
Just wanted to clarify.
Yeah, both of them.
Commissioner Laster.
Shannon, just from my clarification, I want to understand which parcel is which. The one that he was saying is 801 in the gallery and the studios. What a number is that one versus the one that's they're renting to the musicians?
Deb, what one do you got there? That is 001. That is their main office. The other one is the one that's rented out.
So 001 is the main office. And
And the
004
studios.
is that's the renting to the musicians, the Montessori class, and then the unused.
Yes.
And if I could just clarify on the art, the musicians using that space, those are studio and performance spaces, so it's like an extension of our studio rentals into that building. And that's our plan for that building in the next year or two, is to develop it into more artist space, studios, classrooms, and that type of work.
But they're renting that space?
They're renting a portion of that back part of the building there.
Okay. Mr. Chairman, I'd like to make a further statement on this, if you don't mind.
Okay.
So I'm stuck in between a rock and a hard place. I might agree that your 001 property is for the charitable purpose right now. And then your 004 property may not necessarily be used solely for your organization in the manner that you would like it. And I say that because I know I've been here. Again, I'm the executive director of a nonprofit, and part of the arguments and reasons to justify that I still have to pay property tax on the land of our nonprofit is because it has to be used, and that use is very specifically outlined. Okay, so don't get me wrong, I do.
Yeah.
I think property on 001 may. I can support that particular one, but 004, I'm not sure I can support it being tax exempt based on some of the history of this board and the decisions it's made on similar properties or that are tax exempt properties. I think I would be willing to lean in that manner, just from my perspective. So when you hear me say no, it's not because I don't support the nonprofit. I think it should be delineated a little bit on this one.
May I ask a chronological question? My understanding is I'm applying for exemption for calendar year 23. Is that fair?
For 2022, taxes paid in 23.
Okay,
Yes.
okay. Because I do know that, and I understand the school renting that front part is probably, because it's on the very fringe of our mission, but it met our mission, so our board supported it. But that will be finished in May, and that will be unused space, just to see if that adds to your decision making.
Chairman.
So, Mr. Strong, this may be an unfair question at this point in time, but how much income would you anticipate this year from your rentals, from renting to musicians, from renting to the school, et cetera? Not asking dollar amount, asking percentage of your overall income, what would you anticipate?
Percentage, it's pretty low, under 10% of our.
Under 10%?
Yes, sir.
Okay. Commissioner Adcock.
Chairman, so the property that Travis is talking about, isn't that where your office is for rural initiatives? Or not? Yes, not rural.
No, this
Magpie,
building here
sorry.
is the one that
Magpie.
sounds like there's a hesitation. This is the one that, there are musicians in the back, and then empty space, and then the classroom, the school is in the front until May. The other building has our office and our
Okay.
gallery and other studios.
So this year, this will turn it into basically a more usable space for your artists.
And
You
we'll
do
be
have
able to,
some artists, you do have some people,
yeah,
using the space that are doing education.
yep.
Bottom line for me is that for the artists that they're talking about, I've been involved. Scott has done some work for Magpie before. They do some really good things for hardly anything for artists that are trying to survive in the Native community for their art. And this has actually moved them one step ahead, like Commissioner LaCroix said, for economics. They don't have to go sell their stuff for pennies on the dollar. They actually have these studios and these areas where people that are artists, that are native artists, are actually getting the money they should later for what they're doing. And then they also, again, for economics, helps the people to move to the next step. So they do some really good things for our native community and to move them ahead. And like Shannon said, that doesn't make you nonprofit, but they qualify for a lot of these things that we're talking about here on both the buildings for that. And if they're going to move ahead and put more people in there and help more people this year, I'm all for it. Anything that could make anybody in life, you already know that from nonprofits, better themselves and move to the next step, I'm for. So.
Mr. Chair,
Commissioner Roskinek.
one of the questions I was going to ask before Commissioner LaCroix made the motion was that, is it possible, and I kind of see where Travis is coming from too, is it possible to do a partial exemption instead of 100%? I'm not saying this particular case, but
Absolutely. The one spreadsheet we had is a bunch of properties that are partially exempt.
Yeah.
okay, that
That-
was,
The perfect
direction I
example
was-
of that in our world is a church camp that uses the church camp for a summer camp for like 4 weeks out of the year, and then the rest of the time they rent it out for weddings and family reunions and stuff like that. That's a partial exempt.
okay, just thought we'd done that before. I just wanted to refresh my memory there.
Chairman, one more thing. He also said that 10% of his income for these artists, so it's not like he's making tons of money to support what he's doing in one sense. He's doing it again for the recognition of what will come next for this economic development for the people. So on the one building, he does have some musicians, so he's starting to fill it up. He's taking the space and making it for the next step. He's renting the one side because kind of like us, you guys go ahead and use this while we're fixing this side up till we get it done. And by May, that's going to be good to go. So if it wasn't happening and he was going to say next year, we're going to do it differently, I think I would probably do the partial exempt myself. But because he's already moving forward in that step and using that space for musicians, and then, like I said, renting that space until he's got the rest renovated by May, that's just what most people would do to be able to, keep moving forward until he gets those spaces for people. So.
Mr. Chair,
And Commissioner LaCroix.
my final comment. Just thank you for coming here and helping us work through this. And from what I gathered, everything that's been discussed already this morning, even that 10% profit, it all gets turned back into the organization as subsidies to the artist, as outreach for doing the income. So, I, at the very beginning of this, was thinking the same thing, percentage-wise, because we've done that with the Legion and worked through that type of thing. But I think after listening to everything this morning, I think it all goes into the same place. And I think that's what you're gonna take things as they go. So I'm still in support of my motion for the vote.
Got a motion and a second. Is there any further discussion? All those in favor of the motion, which would give approval to allowing Magpie Creative to be exempt for 2022, indicate by saying aye.
Aye.
Aye. Opposed?
No.
Okay, 4-1 passed.
Thank you all for your time.
Thank
Really
you.
appreciate it.
Thank you.
Thank you. No, sir.
Okay, you gotta apply again next year, every year you gotta.
I will.
Okay.
Thank
I'll have to come see your building, Mr.
Yeah,
Strong.
please do. Thank you.
The next one we have on the list is Wings as Eagles Ministries. And again, I want to step outside to make sure nobody's here.
Need to put a mural on that building. Don't they on that side?
Yeah, that'd
We're
be
gonna
cool.
put one on ours now. I didn't know if you know that, Lloyd.
Did you?
We're gonna put a, for that
Okay,
road.
Religious.
this is religious, and I've got the statute here for you, and property owner's not here, so again, I'll have to do my best to actually talk to them before the next meeting. The next, this one and the next one are religious exemptions. So this is the same statute that'll apply to both of them.
This is physically located at Black Gap?
Yes, this is a single-family residence in Black Gap. It's owned by Wings as Eagles Ministries. Wings as Eagles is a relief and agency. I find this on their website and in their corporate documents. Okay, they describe themselves as a ministry and a relief agency. Lori and Gary are the principals of Wings as Eagles Ministries. Wings as Eagles Ministries has something going on in Pine Ridge. I think they own a property, but there is a property and they have activities going on down there. And I think it's a combination between religious and charitable stuff that they do down there. This is a house in Black Gap that they recently purchased that they live in, okay? Lori and Gary live here. Wings as Eagles is an organization owned and controlled by Lori and Gary. They're asking for a religious exemption as a religious organization, and this is a parsonage for the pastors, okay? That's the ask here. My recommendation to deny is based on the fact that this property is not part of the ministry down there, and the home is not a religious society comprised of members like Lutheran or Baptist church or something like that. I don't argue that what they're doing at Pine Ridge isn't worthy of an exemption, and I don't know because it's outside Pennington County. It probably is exempt down there. And that's all okay, but of this property, this is just a home. Now, the statute, you can read the statute, it does grant an exemption for a parsonage, but it defines a religious society. And this is just a ministry by these couple of individuals, and this is their home.
So, Chairman,
If this were a membership and the membership purchased this home for the pastor, that's different.
So Shannon, can I ask you something? So if we have First Wesleyan Church, so our pastor lives in a house, is his house exempt?
Does he own the house or does the church own it?
Oh, no.
Okay, so remember those criteria. It has to be a nonprofit.
Right.
And in this case, it has to be owned by a religious society and used for religious purposes. So if the pastor owns the house, it's
Right.
not owned by the church, so it's taxable.
But if this, what it's called?
Wings as Eagles.
They own this? Is it under the,
Wings as Eagles is a LLC or some corporate ownership, and they own it, but the principals of Wings and Eagles are just a couple of people. It's not a religious society that the law describes, like the Wesleyan Church. There's no members other than the people that live in the house.
so they go down and they do what down in, are they teaching people about God? Are they just doing classes on what? I mean, what is their purpose?
I think it's a combination of charitable and religious. I think they are a Christian ministry that is providing ministry and charitable services at Pine Ridge.
So it says non-denominational evangelistical ministry and relief organization.
Yes.
Working with First Nations people. Mission is to extend evangelistic calling by proclaiming the gospel of our Lord Jesus Christ to all we have for every effective means available.
A few years ago, I had a homeowner in North Rapid apply for an exemption, and then he withdrew it under the same request, parsonage, but it was his home. He was a Christian evangelist, and I don't remember if he was an ordained pastor or not. I don't know. But he traveled around to churches that would request that he come. I assume he got paid because it was a different location every time, and he put on an evangelistic series. That was his business. He had a Christian ministry. But the home was owned by him, and it was his home. This is the same thing, except there's that corporate layer, Wings as Eagles, but Wings as Eagles is just the people that own this home. This is not an organization of members, a society that the law describes. And just like the evangelist, that's his business. He has a Christian ministry, but his property isn't exempt from taxes just because he does something like that.
Mr. Chairman.
Commissioner Roskinek.
So Shannon, can you just summarize what the definition of religious society is? So how do we, I mean, that's pretty vague. I'm just trying to.
This is all I got, is the statute there. Property owned by a religious society and used exclusively for religious purposes.
So let me ask you something. Sorry.
Commissioner Laster.
I want to dive into that a little bit further, if you don't mind. That's kind of my question is going to tack on to what Ross Connect was asking there. We have non-denominational churches. They don't fall underneath an overarching denomination such as the Methodists, the Lutherans, the Wesleyans. How do we classify those non-denominational churches within the county? And do we have any that you're aware of that actually have non-denominational church lands, but also ownership of parsonages that may or may not be connected to the land?
Okay. Two parts to that question. The first part, I don't care whether it's non-denominational or Wesleyan, okay?
Right, I get that.
I can go to the extreme. There's an organization, Cancu-Lutna or something like that. They are a Native American religious organization. As long as it's a society or organization that has membership and multiple people, what we would normally think of as a church, okay? I'll say that meets the definition of society. I don't care what denomination.
So it has to be a group of people, not just a a traveling pastor, if you will. I'm just
Yes.
trying to get a clarification.
I take society as a group of people and not just one, okay? Now, then, the church that owns a parsonage. So if the pastor owns his home, he's not a church, so it's not exempt. He pays taxes on it. It's his house, okay? If the church owns a home and the pastor doesn't live in it, then it's on the tax roll too, because it has to be owned by the church and used for church purposes. And we do have homes where the pastor wants to live in his own home, so the church rents it out to somebody else. And I don't care whether they pay rent or not. The fact that it's not a parsonage makes it taxable.
Okay. So this says it wasn't until 2004 that WAEM, which is Wings on Eagles Ministries, is acquired 114 acres of property on Pine Ridge Reservation. Property that now serves as the headquarters of our Christian Interfaith Ministries. So isn't this an interfaith ministry that owns, does it have to have 10 people in it? Or is it serving, there's 114 acres. They're not serving themselves. They're ministering. And do we have to say, all four of us have to say, well, we're in the Wings as Eagles Ministries? Or we're in that church? That's where we learned about God. That's where, is it different? And why is it different? You said it's because it's owned by two people. Well, Wesleyan Church is owned by, I understand, an organization in a sense. These guys are an organization. It looks like also they have done work in Wyoming and Montana for the Blackfeet tribe, other Native Americans tribes, and now they're in basically also helping Pine Ridge. So they do have kind of a congregation, but it's not called, Wesleyan or Catholic, or it's called WAEM.
The congregation does not own the property.
Right.
Your Wesleyan church, the congregation owns it, or the parent organization does. In this case, it is just these couple of individuals. They own the entire organization.
Which is WAEM, which is a ministry, right?
Yep.
So we won't call it Western, or we won't call it Wesleyan, we'll call it a ministry. And I guess I'm not seeing the difference unless these people just, started to go out and just walk around to people and say, this is who we are, this is what we're doing. They're actually serious about what they're doing for their ministries, so they are reaching out to people about Jesus Christ. They started in 1994. They didn't just start. The leadership of a pastor, she is a pastor. Now, if she's just a person like Deb and I'm going to help Native people, that's not a ministry. Well, that could be a ministry, but I'm not ordained to do what I'm supposed to do by God as being a pastor. Those things add up to me just because it doesn't have what you call traditional church. It's doing the same thing to me.
Doing the same thing, but the law says owned by a religious society and
Well,
not owned by an individual.
WAME is a religious society because it says Wings on Eagles Ministries.
Yeah.
That's not a religious society talking about Jesus Christ?
I can create an organization of Shannon Rittberger for nonprofit and create that LLC to own my own home, and it's just me that owns that corporation. The corporation is just a cover for the individual.
But I don't believe this is a cover. I think if you're doing this since 1994, you have went in, and I'll give this to the rest of the commission, you have went in there and been doing this since 94. You went into Wyoming, you went into Montana, now you're in South Dakota, and now you've actually established property as well. Are they buying the property because they don't want to do ministries? They're going to do something else like build a bunch of houses and make these people pay for building their houses? I'm not seeing that. I'm seeing that they have a track record, and I'll pass this down.
Commissioner Hadcock.
Track record for this.
Does it appear like they have, if you don't mind, just to follow, does it appear like they have followers that are there in the area working with them? And I'm just trying to understand that. I know you're passing it down, but I didn't know if you read that.
they've went from different areas, and I don't know if they have got properties, and I didn't look thoroughly, properties in like Montana and Wyoming and different places, but they actually bought 114 acres on Pine Ridge Reservation. It's not a place that you want to just go buy some property and think you're going to just set up home and set up camp unless you actually are going to do some, to me, some real work. And then this is part of their parsonage.
You know, the IRS provides quite a few tax breaks or incentives to those that are in the ministry or pastors per se, relative to housing, et cetera. To me, this one here does not sound like a parsonage per se that we would provide tax exemption from. And so I'm not going to support this being classified as a religious parsonage.
I encourage you guys to read through that packet a little bit more, just to get a little bit more information on kind of what they are and what they do, so.
Now, to be clear, the activities that they do are outside Pennington County, and I think that property is exempt down there, but it's another county.
Right.
We are only looking at the home here in Pennington County.
Right.
That's all I was talking about, too.
Right.
Well, they knew that this was scheduled at this time. They could have been here. They still have the opportunity.
They can still come
No matter what
back.
action we take.
Yeah,
Still
so,
have the
and
opportunity to come back.
I didn't get a response to my email to them, but I'll go to more effort to try to find somebody, because this next time will be the last time for this year anyways. They can always come back next year.
Do you know when they acquired this house?
You see that there? Recently, summer of '21.
Okay.
Does it say a year?
The other question I have is with Black Gap, with planning and zoning, is this would this fit within the criteria?
It's
within
a
that
single-family residence, and it's being used as a single-family residence. This is their home. They're not saying they're doing anything else out of this home. So I don't know why planning and zoning would have a problem with them living in it just like anybody else would live in another house.
Mr. Chairman. So the home is actually owned by the ministry itself, or is it owned by the two individuals as in their own names? I get it, the ministry is owned by the individuals, but is the house in their names as individuals or in the ministry's name?
Wings of Eagles.
Mr. Chair,
Commissioner Oskinek.
if they would have been here, I'd probably be a little more open-minded, but I'll make a motion to deny.
Got a motion to deny. Is there a second? I'll second. Further discussion? All those in favor of the motion indicate by saying aye.
Aye.
Aye. Opposed?
No.
I need to do a roll call on it.
I think you have 3 ayes.
Hadcock?
No.
Rosknecht?
Yes.
Drews?
Aye.
LaCroy?
Aye.
And Lassiter?
No.
So 3-2.
3-2, motion. Motion approved to deny.
The next one we have on the list is a similar argument. It's owned by Open Hands Outreach, and property owner is here. Corey Carter, did I get your name right? Okay, I wanted to make sure I got it right. So, again, single-family residence in Rapid City. It's owned by the corporation named Open Hands Outreach, and it is Mr. Carter's residence. The property was purchased just this last October in 2021. When I look at the corporate documents for Open Hands Outreach, the principal office is in Tacoma, Washington. The Tacoma, Washington address is the home of Daniel Peterson. He is the owner of a company that helps individuals form 508c1 corporations for the purpose of avoiding paying property taxes. Okay? Open Hands Outreach is associated with Corey Carter and his business AltMed Services. And AltMed Services has a building on Sturgis Road, and he provides alternative medical services out of that office. Mr. Carter claims that Open Hands Outreach is exempt from property tax because it's a 508c1 corporation per IRS code. Our state statute requires a 501c3, a little bit different. But I don't think, to me, that's not as big an issue. I think he'll have more comments to that. Mr. Carter claims that the 508 is a non-taxable status through federal law. He stated in his paperwork that he provided me that supersedes the state and the county, and that he doesn't think that the Board of Equalization here even has jurisdiction over this exemption. Now, in addition, Mr. Carter claims that the property is used as a parsonage for the health ministry of AltMed Services, and he claims to be an ordained minister. I asked Mr. Carter what organization ordained him as a pastor, and his response is that I am the religious organization. Okay? You've got a copy of the state statute for a religious exemption. I'd like to split the argument here between the state statute and this 508c thing with the federal tax law. I'd like to differentiate between the two, and I think maybe Mr. Carter will have some comments here. The state statute in South Dakota says that an entity requesting an exemption, in this case a religious exemption, must apply. The property must be owned by a religious society and used as for a religious purpose, and the property must be a 501c3. The state statute doesn't grant an exemption for a 508. The claim that this property is a parsonage, I think, is the same argument as the last property. There is no religious society that owns this. It's owned by an entity of which Mr. Carter is associated, and his AltMed Services. AltMed Services is in a rented building, right?
Correct.
Yeah, and there's no argument about whether that's exempt. We're looking at the home here. A little bit more to the story. Mr. Carter applied for an exemption from property taxes on his previous residence in Meade County last year. It was denied by Meade County.
Not true.
It was appealed then to the Office of Hearing Examiners in Pierre. The case was dismissed.
Not true.
And then he filed to circuit court. And my conversation with the county assessor in Meade County is that nothing has happened on that circuit court appeal in Meade County. The property, the previous residence that he owned just prior to purchasing this, was taxable in Meade County last year.
Not true.
And I'll let Mr. Carter speak.
So do you want to address those areas, the three areas that you said were not true, please?
Thank you. And I'm not used to meetings like this, so if I outspeak or do it wrong, please excuse me ahead of time. I was ordained as a minister in 1972 by an organization called Jehovah's Witnesses. I have since broke and started a separate organization, so I have a ordained status, and I am a minister. I am also an alternative medical doctor. The procedure that we have, we applied to the federal government for a religious exemption. They supplied it. My belief, as was mentioned with this gentleman here, is that the county, the state is not one that can determine a religious organization. And when I went to Black's Dictionary to find what a society is, a religious society, it is pretty much undefined. I treat people, work with people from all 50 states, and I've had people come to me from 36 different countries. My basis for religious non-profit alternative medicine is almost all medicine done in the world today is based in evolution. I base my medical expertise in the scripture and what the scriptures talk about as to regards to dietary use. We are specifically an SSM, self-sustaining ministry. The building in front of us here is what I'm applying for. At first, I was told that I could do it as a parsonage, and then Meade County corrected me and said that it was a rectory, and I don't know which is the difference between the two. Part of what this is used for is to allow people who have little or no income to come and stay in the basement, and we provide that without charge. And yes, it is a place that I am currently living in and I take care of for ministry purposes. The denial, according to the document, says that I need to apply by, I think it's November 7th.
November 1st.
November 1st, thank you. According to my lawyer and how we read that, it doesn't say it is annually renewable. It just says it has to be done by November 1st. And that is the issue that is in question in Meade County. I presented to them. I told them that I'm presenting as a 508, not a 501, which I do have a 501 as well. And they said that, yeah, Mr.
Ritberger. Shannon.
Shannon.
Yes.
Shannon's comment, when I pointed out to him that I was applying as a 508, they said, well, just cross out the lines and put 508 in there and we'll accept it. And we were accepted for 3 years. The issue that they came up with was that I was under the assumption that because the document does not say annually renewable, it just has to be done before November 1st, that I had met those requirements. And that is what we will be taking into court, is that the state had every right to put whatever requirement it needed on that page, and it did not. And so according to my opinion and the lawyers, we have met those requirements. And that's the point that we're going to make. And when we went to I lost the top proper term where that we're challenging the county's statement.
Office of Hearing Examiners.
The appeal.
So, the appeal.
State office,
The
okay.
appeal, thank you. The assistant attorney for the state or for the county made the assumption that this was a court hearing, and he brought in a court requirement that there had to be a lawyer there. Because it was not a court hearing, I could have represented myself, but he would not allow that. And if I had been able to represent myself, I would have come up with the arguments that we've had previous, that we are a religious organization. I'm not going to argue society because it's undefined. And we are non-denominational. We also maintain a school. It is not registered in the state because naturopathy is not registered in the state, but we teach those health principles. I also work with people who cannot afford medical care. We have dozens that we don't charge anything for. We do charge for our typical services, and all of those monies are used to support the ministry. I would also like to make a complaint when I pointed out to Shannon that I'm an alternative. His attitude changed dramatically when I was showing him the office, and that I am one that does not believe in the vaccine. He took exception to that, and so I believe there is some bias on his part in this presentation. And I don't know that I've answered all the 3 points or
Well,
not.
I'm curious as to why when Shannon was saying that Meade County denied, and you said that's not true.
They did not deny. What their exception was, and we've got the records for that, their exception was I didn't apply every year. And so because I didn't apply every year and I was late making the application, they denied it on that issue, not because, and they accepted it for 3 years.
Okay.
Chairman.
Commissioner Hadcock,
Can I clarify on that point, Mr. Chair?
absolutely.
The appeal went to the Office of Hearing Examiners because Meade County denied the exemption. The property in Meade County, the home prior to this, is on the tax roll and was. That was the whole point of the appeal, is because Meade County denied it.
Mr.
It
Chair.
was taken off of the tax rolls.
Mr. Carter, are you in Blackhawk, that area? Where's your,
I'm in, the house is,
your move there?
yes.
Okay, so, I'll just tell you a story. I don't know if this is to this, but I had a lady that, was a friend of ours. She went to this, Mr. Carter, for alternative medicine. She went to, Mayo Clinic, and she was full of cancer. And she was supposedly, not supposed to make it. So she started going to Mr. Carter. People think this is crazy, but he started giving her vitamins and different things that actually I saw her like 3 months later, and she said, "Debbie, I feel better." I'm like, "Okay." And then 6 months, she said, "I don't have any more cancer," because she was before she was like, "Oh," and then she was just like nothing was wrong with her anymore. So I said, "What'd you do?" And went to Mr. Carter for alternative medicine. Well, I didn't truly believe because Mr. Carter might not have radiology stuff and be able to check and make sure she had all these cancers and these different spots on her gone. She said, "No, I went to Mayo Clinic and I didn't have any spots." So I don't know what Mr. Carter is doing, but whether it's religious or what he's doing, but this lady's still alive. And Mayo Clinic told her, and this is a true story, to go home and die. So they don't quite say it like that, but there's nothing they can do for you. So I don't know if you're using religious. I know you're using vitamins and different things, and this is not the first time I've heard about what you do for people. So I don't know if it's under religious or whatever, sir, but I just wanted to say you're doing some amazing things. I don't know, maybe I need to come see what you do, but you've done some really good things for people through the alternative medicine. If that's through religious or what he's doing, I don't know the rest of the story about you, except that you say you're, pastor and you believe in evolution and you believe in the Bible, and that's how you do things. But I just wanted to put that story out there because some of this sounds like he's just like this kook. Okay, I'm not trying to be mean to you, sir, but he's doing some amazing stuff with this alternative medicine. So I don't know what you put that under. If it's his evolution and how he does his stuff, I can't exactly tell you how to do it, but I can tell you from people that he has saved or he has done some really amazing things with his alternative medicine. It's working. So I don't know what you put that under. I don't know if you can put it under anything to do with that. But he is what his work is truly. I don't know what you classify it under, guys.
So are you a certified medical doctor?
South Dakota does not recognize naturopathy as a profession. So we fall under the exemption. Actually, the taxing board recognizes us and gives us the same privileges as a medical doctor. So my services themselves are not taxable. But anything that I would sell or offer as like a supplement or something along that line is taxable. And so every month we have approximately $2,000 that we pay in state sales tax. I also have approximately 5,000 clients, and I do not believe in evolution. I believe that goes contrary to Christianity. My basis for medical work is based in the Bible's dietary concepts, and thank you for sharing that. It always gives me good heart.
Yeah, I appreciate that.
Mr. Chair.
I'm not understanding how this fits under religious.
Yeah.
Commissioner LaCroy.
I kind of agree with Mr. Drews. You know, my wife's parent was a chiropractor, plus his wife did a lot of had a vitamin store and did a lot of alternative medicines, acupuncture, among other things. And I've heard some pretty amazing stories from the work that they've done also. But I think the fact comes down to on this is the ministry part of it, from my point. Just from, you know, I know her parents, you know, they paid their taxes, did everything like they did, and still went out and did what they did. But I just wanted to share that with you guys too, that it's not unusual, but I just don't know if I followed the exempt for religious on this.
Mr. Chair, may I respond to that? Commissioner LaCroix's comments. So he makes a good point. The work that Mr. Carter does on another property in Alt Med Services, this is his home, but in the other property, he can very well be doing some good work that benefits a lot of people. And whether he is a licensed physician or naturopathy or whatever, that's the business he's doing over there. This is his personal residence. And we have a lot of physicians or various other types of medical workers in Rapid that are doing good work. And many or most of those are Christians. That infuse some of that into their business. But their home is not exempt from taxes because they are a Christian nurse or doctor. This is a home. Like Commissioner LaCroix said, they pay taxes just like every other business owner.
But Chairman,
Yeah.
here's the difference. If I know he does stuff for free for people because if they don't have the money in his business as well, but he's also saying he's carrying that, which he's his business, into his house, which he's doing people, letting them stay in his house for free and stuff for open. Can he be partial exempt or anything for what he's doing with his business for helping others, kind of like other?
The law we have is religious society right there. And that's the only law we've got. Again,
Not through charitable of any of those other exemptions?
he doesn't meet the definition of charitable and didn't ask for an exemption under that. The closest it would be is religious because he claims to be a pastor. And I say claims, I don't doubt you. I mean, he says he is a pastor that lives there. Not everybody that does a good work is exempt from taxes. We have a law that specifies what needs to be met. There are a lot of people out there that are doing a lot of good, charitable, Christian work, and they pay taxes.
So, sir, is your property, Mr. Carter, is your alternative medicine, are you exempt anywhere on your alternative medicine or anything? Is there any exemption? You said you had a 508C1?
The property is leased, so
Well,
it's on the tax roll under somebody else's ownership.
but is your business under any kind of exemption for what you're doing?
Correct. That's what I applied to the federal government for, and they gave me that exemption,
And why did they?
because I met their qualifications.
And what was those
That I'm a
qualifications?
religious order, and that I'm also teaching, I'm also charitable. I do many other things that met their qualifications. So and then a point that I would like to make is I have two properties. One that I am not asking for any exemption on at all, because it is not being used as a parsonage or a rectory. I'm asking this one is because it is being used that way. And in this one, I am also offering rent space when somebody can't afford to come, they can come and stay in my basement. And in that regard, I've also provide food for them as well. I take care of my people.
And Mr. Carter, you said you do have a 501c as well?
I do.
And that's under what? The
That one
same?
is Alt Med Services. And then the one that we're talking about here is Open Hands Outreach, and that one is the 508. And both of them have been applied for to the federal government, the IRS, and both of them have been accepted by the IRS, which I have a hard time understanding if the federal government acknowledges the existence of these two I don't know what the right term is, businesses is loosely termed, is that why can't the state or the county?
So if the federal government under 508c1 says he's religious, says he's got those exemptions, why wouldn't it be different? Why would it be different for us for these properties?
The federal government says he's exempt from income tax. We're looking at property tax in South Dakota under state statutes.
Okay, so if you don't have to pay income tax and you're still religious and you have all those other exemptions, why
There's,
wouldn't it carry over because he said he's ministering in his house? Maybe the alternative medicine, because he's leasing it, of course, that exempts him from, which makes sense. But how about his ministry, the open hands that he said he applied for, and that he lets people come in his house for nothing?
there are a lot of properties paying property tax that are nonprofit in Pennington County.
But do they have a 508c1 that says they're religious and says that they are put under those exemptions because of income tax?
I think, Commissioner, that the difference is that the federal law doesn't carry over to the state and county. And so what IRS regulations may provide for him with his profession and so forth does not apply to South Dakota state government nor to Pennington County.
How about Open Hands Ministries, which is basically, a different organization that he says he's pastor of, which they have recognized that he is a religious organization to get tax exempt. See what I'm
They're
saying?
saying that.
Yes.
Right, but according to codified law, if you don't mind, correct me if I'm wrong here, but what I read from earlier, it's only your 501c3s, 501c3s, 501c7s, but you're a 508, not a 501. And the state,
All of those fall under Title 26. So if you acknowledge Title 26, you have to acknowledge all of them.
except the states can restrict and say that we recognize this piece of it to fall underneath this category that we've defined. There is a separation of, states' rights. They get to do that. On the federal side, that just means you don't have to pay federal taxes underneath the 508. But a 501, my organization's a 501. I still have to pay income tax, but we are still considered a ministry. We don't have to pay sales tax or things of that nature. So there are some very specific nitnoid rules and regulations, and the state can pick and choose underneath their codified law what they recognize as a ministry or not, and how that has to go. So that's where I'm kind of, if you filed in your 501c3, I might not have, as much as an issue with it as opposed to the 508, because the 508 is not listed in the state statute of being able to be property tax exempt.
Meade County, when I pointed that out to them, said cross out the 501, put the 508, and you are accepted. And then the exception that they said, which is not accurate, that is that they denied it on the grounds that it wasn't put in November 1st for the next year. And what I've tried to present to them, and my lawyer will present in case, when you look at your paperwork, it does not say annually renewable. It just says by November 1st.
But that's Meade County, is that correct?
No, that's a state law. That's a
No,
state.
no, I'm saying what you applied was in Meade County, is that correct?
Correct.
I can't answer why they, and I'm not gonna say they made a mistake or not, I'm just gonna say, I can't answer to why they did what they chose to do. And apparently, that's why you're sending it to the courts to have it clarified.
We're having the one statement clarified with the Director of Equalization by November 1st for consideration during the County Board of Equalization the following year. Nowhere does that statement say that it has to be annually renewed. And that's the only reason it was denied in Meade County.
I understand, I just can't speak to Meade County's process and
I
what they're.
appreciate that.
So, but I was just giving my opinion on the route that I think it should have gone here in that manner based on our codified law for the state.
May I make a final comment, Mr. Chair?
Yes.
I think we've got into the weeds on this. Again, we have a state statute that grants an exemption for a religious society that owns a property that is used as a parsonage or rectory. This is owned by an individual. There's some confusion in the corporate paperwork that the principal office is in Tacoma, Washington. But
Not true.
But it's Mr. Carter's business. This is not a religious society that owns this. Regardless of what good he does in the home, it is his personal residence and doesn't meet the definition as a religious exemption.
Religious society is not defined in Black's Law Dictionary. Non-denominational would qualify. I have over 5,000 people that come to me to get not only nutritional benefit, but I also offer advice in marital issues and raising kids and everything that a minister would do. I am a minister, and I would argue or feel quite upset that I am not a religious society by this one man's statement that he can't back up, because there is no codified statement as to what a religious society is. The federal government has acknowledged that I have a religious society. It is not just a home, it is a place where that I can conduct a lot of ministry activities as well.
I'm going to make a motion that we uphold the Equalization Office recommendation of denial on this.
Second.
Mr. Chairman,
I got a motion and a second. Commissioner Lassiter.
I would be interested to collect all that data, all the documents before making a decision on my part. I would like to see the appeal process, how you've applied for it. So I'm just interested to get all the facts, because I've heard from Shannon, his take on the interpretation of it, and then Mr. Corey, right?
Carter.
Carter. I'm sorry, I wrote down the wrong name. And I just want to make, I just kind of want to see how that process unfolded, so I can read it. I get it. Everybody, there's a documented process of what you've already transpired through. I'd like to read and see. It would be interesting to know if he was given a tax exemption for 3 years and then not, just for my own personal information. So
I'm of the opinion that there's so many parts to this.
it is.
That this is something that's going to have to be decided by somebody higher than the Board of Equalization locally in the county. So that's why I made the motion.
Mr. Chairman.
So Chairman, can we continue it to look at, when?
He has the
when-
opportunity to come back.
So in 7 days, if we deny it, we can look at, or can we continue it till that 7 days to gather more information?
The law says that Mr. Carter has the right to come back and appear before the board in 7 days.
So can we continue it till then?
I,
For more
I wouldn't
information?
say that. I don't want to get into the rules of the motions you make, but the law says when the commission makes a preliminary decision, so you actually act on it, the property owner has a right to come back 7 days later. So I think you need to take action now, but he has the right to come back in 7
I'm
days.
not the property owner.
The
And
property
I've
owner,
already tried to establish that. It is owned by Open Hands Outreach. It's not an individual building. It is owned by them, and that was some of the argument that you had with the previous one. This is not owned by me.
I think this is, if we don't make a decision today and wait for the 7 days to make a decision, then that leaves it open for another 7 days. There's
exactly.
other options if we deny it, even again in 7 days, he has the option of appealing that.
Yeah, I think you need to make action now or we run out of time later. Then he wouldn't have time to come back.
Commissioner LaCroy.
I agree with that analogy. I think we take action today and he can appeal. I'm not denying the work that he does or anything along those lines. I think we could each do some individual research between now and then and so forth. But I also agree with Mr. Chairman that I think this is above us as an equalization board. It needs to be sorted out. So that's why I'm going to support the motion on the floor.
So Chairman,
Commissioner Adcock.
I can support that if he's going to come back in 7 days, so we can look into it a little bit more. If we want to move it forward, then I will probably say no. I would like to look into it because I have seen through the Gerson therapy and some other stuff, they will not acknowledge alternative medicine for some reason in a lot of states or a lot of areas for different things that they do. And I don't know if that has some added issue with this or it doesn't make any difference, but I would also, like Mr. Laster, look into it a little bit further and see what's moving next. Not that you're wrong, Shannon. I've just seen some, and not that that makes it so he should get exempt. Some things that he's done, and he doesn't charge people, and he does some really miraculous work for people that a lot of times, like I said, people are not acknowledging it as medicine or anything else. So maybe I'm missing something with some of the information that we're talking about today. So
One clarification. So do you charge some people?
We do charge some people,
Okay.
yes.
Thank you.
That's how we afford to pay for the ones we don't charge for.
Any
Mr.
further
Chair,
discussion? Commissioner
I'll
Oskinen.
support your motion, but I would have also supported a partial exemption. Just wanted to put that out there going forward.
Okay,
Mr. Chairman.
discussion.
And I just want to point out to Mr. Carter, whichever way this goes, especially if it's denied, I would definitely ask that you present all your documented evidence so we can at least look through that, because I think that may help one way or the other. I might be wrong, but I'd really like to see it documented, this whole process that you've gone through, so we can see that. If it's denied, you want to come back in 7 days to appeal that piece of it.
Thank you.
Any further discussion? All those in favor of the motion to uphold the recommendation of the Equalization Office indicate by saying aye.
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 Opposed?
No.
Okay, roll call again, please.
Hadcock?
No.
Rosknecht?
Aye.
Drews?
Aye,
LaCroy?
Aye.
Laster?
No.
3-2 again.
So, Mr. Carter, I encourage you, if you want to come back in 7 days, but the main thing is give us some of that documentation so we can go through it before, you come on the 7th day. Some of the documentation of some of the things that you do.
Where would I deliver that documentation
Hey,
to?
How about we set that up right now?
My personal thing is I do not want to deal with this guy. He is biased. So can I deal with somebody else?
You can send it,
We can get it to Holly. Mr. Carter, would the 20th work for you to come back? Like 4 o'clock?
It should work. I don't have my schedule, but I can adjust that far out.
Okay, so let's plan. You let me know, let somebody know if that doesn't work. But the board only meets for so many days, so we don't have much option. So it'd be nice if 4 o'clock on the 20th, if we could get back to here.
That work, Mr. Carter?
Yeah, let us know if there is a problem. So the board wants documentation.
Can you give me an idea of what it is in documentation that you're asking for?
You have a 508, 1C. How does that recognize, I mean, do you have any documentation how that's recognized religious-wise? Do you have any documentation that, you know, that you do religious organizational things and why that would classify you as a pastor? Some of the things that today we're having a hard time recognizing just by you saying. Some of that is not always by proof, because I've seen some of your work. So, or have, yeah. So, bottom line is Shannon's saying this, how do you make it so, based on those, religious, the 10-4-9 property owned by religious society, how are you fitting into that? Make sense?
It does.
And I'll just tell you, sir, you can trust Shannon. I know he doesn't always make you feel special, which he does to people sometimes. But when it comes to doing things and sending us documentation and stuff, sir, he will give it to us. So if you want to give it to Holly, that's fine. But I can tell you from hanging around Shannon, he's very trustworthy. So I know he doesn't say all the right things to all of us all the time. I do the same thing, but he's very trustworthy, sir.
So you can submit your information to Holly's office. This is the office of the
One of
commission.
the things you wanted to see was
The commission has a office manager, and it's
county, wasn't
the
it?
office right
Yeah.
next to
That's what
yours.
he's,
I was gonna make sure.
If you get it to them, I will submit something to the board. I'll get you a copy of that, so you have that in advance, all right?
Thank you for listening.
And Mr. Carter, I would really like to see that 3 years exemption that you were given by Mead. I mean, seeing that documentation is a good thing.
Do they keep records? I don't know that. That's not my, so I just asked
It would have
them-
been documented in minutes, right?
I will
Whatever.
find it.
Okay.
And like I said, I'll give it to you prior to the 20th.
And Mr. Carter, Shannon, when you can't find stuff, sometimes Shannon's good at finding it, so he is a good resource as well.
Okay.
Okay.
So we'll see you on the 20th at 4.
Apologize.
I'm all right.
Next item we have is the Rural America Initiatives.
Thank you, Mr. Carter.
Thank you, sir.
You can call. Okay. All right. Yep. Okay, so we have one more, and this is sort of unusual. Okay, so we have, and I don't know your name. Somebody representing Rural American Initiatives.
Rebecca Kidder with Peebles, Kidder, Bergen, and Robinson, and we have Bruce Longfox, who's the Executive Director of Rural American Initiatives.
Okay, all right, so just an introduction to this, and I'll give you a copy of state statute. This goes to the application for the exemption. We're not gonna, I don't want to argue whether the organization is an exempt entity or not. I don't think there's any point in that. I think I think next year, the property could be exempt from property taxes. I think that's not something we need to argue about. The property owner, is it Longfox?
Yes.
Mr. Longfox came in just last month, I think in response to a tax bill anyways, made an application for an exemption, and we have it dated, I think it was March 14th. So we did not have an application by November 1st. The state statute says that any entity requesting an exemption must apply by November 1st. And that's to me, that's the only argument here is we never had an application until March 14th. The property has been on the tax roll for a couple of years. I think Mr. Longfox assumed that it would have been exempt, but we never got an application till just this last March. All right? Now, you approved one earlier on a list that did the same thing, brought in a late application, and we just held it till the following year and presented it to you, and you just acted on it this year. So we've had, and it happens every year, there's late applications there. This is not the first time. So I don't want to get into an argument about whether this entity is exempt from property taxes or not. I think they would meet the definition of one of the statutes. It just comes down to they didn't meet the requirement of November 1st application.
You may present.
Well, good morning, Commission. I know you've had a long morning, so we'll try to make it brief. And Rural America Initiatives operates a Head Start facility it constructed with federal funds, with private donation funds. RAI is one of the oldest nonprofits serving the Indigenous community in Rapid City in existence. This facility serves low-income children. It provides them with an educational background to be able to succeed in life. RAI uses this property exclusively for Head Start. This property was on the tax rolls owned by another entity. In 2017, RAI filed the deeds with the Office of the Registrar that listed their address. That is not the address any tax notices were sent to, and the exhibits show it. REI found out that taxes were being assessed and had been raised significantly because they built this facility, again not receiving a single tax notice that taxes were being assessed higher or that they were being assessed at all, because their accountant found the property on a list in a publication of properties up for tax deed sale. They got alerted by their own accountant, and they immediately came in and paid all the taxes of over $360,000. Mind you, this is not a wealthy organization. They cannot use federal funds to pay the taxes on this, but they did. The issue in this case we dispute is the state statute requires in several places, and we cite them, that the property owner be notified. Be notified that taxes are being assessed. Be notified when those assessments are increased. We cite to South Dakota Codified Law 10-11-16, which is about assessment. And they never received notice. So we went to try and figure out why. Why would the county send tax notices to the wrong address? We talked to the Department of Equalization. We are giving you in Exhibits 1 through 3 the actual deeds that show the address they sent the notices to aren't the address where RAI was. The address they sent the notices to hadn't been RAI's address since 2016. We're giving you the Secretary of State filings to show they properly notified the Secretary of State when they changed their address. That address matched what was on the deeds as originally filed when they purchased the property in 2017. We've given you a copy of their annual report in Attachment 5, filed with the Secretary of State. Attachments 6 and 7 show that address is published on the South Dakota Secretary of State website and the Pennington County Department of Equalization note. The taxpayer didn't cause the issue of notice of assessment not being properly filed with them. They didn't take any actions to file an address to which it was sent with the Register of Deeds, with the Department of Equalization. And so our only issue here is notice. Notice of the original assessment as well as notice of the greatly increased assessment that occurred in 2020 and 2021. RAI has never owned property used for nonprofit purposes. And so had they received the notices, they would have known, hey, we got to go get this exemption. We understand at this point that, November 1st is the deadline. And we are asking respectfully for the commission to consider REI's purposes, which is to provide education to low-income families and to provide charitable purposes for them, and to ask to really consider this notice issue, because it contributed to the situation in which an exemption was not properly filed timely. It doesn't serve Pennington County, and certainly doesn't serve the community, to take over $360,000 in taxes and late assessments against an organization that is purely nonprofit, that provides such an incredible service to the community. Those taxes were paid in February of this year. So the other part of it is it doesn't affect the budget because you didn't have them to spend till this year. And so for those reasons, we respectfully ask you to consider granting an exemption for all 4 years, or at least a few of the years. Alternatively, at least not approving the increased assessments that occurred after 2018, because we certainly didn't get notice of those, and that is required by statute. Thank you, Commission.
So Shannon, where the notice is going to?
Do we have an address?
It's right here. Hang on, I'll find them.
They were going to 919
Come on up.
Main Street.
Yep,
Come on up to the microphone, please.
right here. Bruce.
Hello, my name is Bruce Long Fox. I'm the Executive Director of Rural America Initiatives. The notices, including 2022 assessments, were going to 919 Main Street, Suite 112. And I had given a change of address to the treasurer, the Register of Deeds, and to Shannon's office in February, but the notice for 22 still went to the 919 Main Street address. And
you have no affiliation with that address?
no, well,
Not since 2016.
2014 was when we left there. We rented there for 28 years. It was Mr. Duchef's building. But then we moved over to Hanny Shaffy's building in 2014, May of 2014.
So that's 520 Kansas?
What's that?
Annie's, is that 520 Kansas?
No, it was 628 and a half 6th Street.
Okay.
That was the address on the deed that was filed by First American Title when we purchased the property in 2017. First American Title filed 3 documents with that address on it, and I'm not sure exactly. They're included in our packet, but notice never went there. It always went to the 919 Main. And we think my attorneys identified a state law that requires Shannon to give notice, SDCL 101120. I'm shaking here, sorry. The assessment of the property of any person or agent residing in the taxing district shall not be raised until such a person or agent shall be duly notified of the time, place, and intent of the township, town, or city board of equalization to do so. And such notice shall be by personal service upon the owner of the agent, or by leaving a copy at his place of business or last place of residence, and shall state the time, place, and where the board will be in session to act upon the matter. The first time I knew that we owed any taxes or there were any problems is my banker called me on February 16th, and he said, you better contact the treasurer's office because there's a problem with your taxes.
Yeah.
And so I did, and they said, well, you haven't paid for the last 4 years.
Wow.
And so you owe $362,510, I think it was. And that I didn't know what a tax certificate was even, but my banker then told me that he said somebody could buy that and charge us a higher rate of interest. And so I contacted Casey Peterson, our CPA, and said, do we have enough money to pay this? And they said, yes, you do. And so I had a cashier's check made out, and February 18th, 2 days later, I got down to the treasurer's office and paid those taxes in full. And then I asked the director of Equalization's office how to file an exemption, and nobody in that office knew. There was an older man that finally was called to the front by the secretary, the receptionist, and he said that Shannon can answer our questions. And so he gave me a business card for Shannon. And then I did talk to Shannon. It was just by accident in the hallway. He said, well, November 1st is the deadline for the application. But we would have applied for exemption had we known that we owe taxes. Even in that first year, 2018, if we'd have gotten that $19,000 tax bill when the building was being built, then we would have gotten a lawyer to help me, because I don't know much about that stuff. I hate to say I'm ignorant, but in the tax area, I am.
Chairman.
And, so that's our argument, is basically that Shannon did not do his job. He's not only supposed to notify us when he adds us to the list, but he's supposed to true up the list of addresses every year. And for some reason, he or his office does not do that. And I suggest that that's something that needs to be done, because it is state law that he do that. But that's our argument, is lack of notice and lack of opportunity to apply for exemption because of that lack of notice.
Attachments 8 and 9 are copies of tax notices showing that they sent it to the Main Street address.
Just a
Commissioner
question,
Duda.
Mr. Longbox. Did you have property that because you were leasing before, you didn't have property that you owned, right, until 2017?
Right.
So that's probably the first clue when you're first learning stuff, is he didn't own property where he's like, okay, I got to go tax exempt this property, and there's a whole different process that I have to do. I just believe because I'm a nonprofit, I'm going to guess this, if I'm right. I'm tax exempt, so obviously when I own my property, they should know that I'm tax exempt. I'm going to guess you didn't know the process that you have to apply for tax exempt on property, just like you would your rural initiatives. You have to, 501(c), all that kind of stuff.
Or
Right.
the state.
Because before you didn't own property, that was all leased.
Right.
Am I correct?
Right.
So then when this process came, and maybe Shannon, to his defense, he's not going to know you're a nonprofit as a entity. He's not going to look you up until you are put on those exemptions, meaning you apply for it. Then he knows rural initiatives. He won't go look on a website and see who's tax exempt, you guys. I'll just tell you that, to his defense. Then you come in and then you apply for it in 18, because remember, you thought you had it already, right?
Right.
For 18. But then you never did it then because you never thought about it. He wouldn't have known about that because, like I said, he won't look up. You have to apply for tax exempt. So if you never applied, he won't automatically think, well, rural initiative's been tax exempt. They got property now. He's not going to know that unless you come in and say, I would like tax exempt on my property because I am a 501(c). Make sense?
They do understand, at this point, but had they received those tax notices,
Right.
had they received the notices as required by statute, they would have corrected this right away.
Yeah, but you don't own property at your house or anything else. I know the process he might not understand on the tax exempt, but we know on property, if we own our house or anything else, that we will get those tax notices. And they don't usually, like I said, they won't contact him, in all fairness, if he's not put under that process. If he never was for tax exempt property for anything under rural initiatives, Shannon wouldn't have known. I mean, do you see what I'm saying? He wouldn't have known.
We do understand. Our contention is not providing notice of taxes, not providing notice of increased assessments. was the primary reason this didn't occur,
Okay.
right?
My,
And
my,
so that's why
okay,
we're
folks,
asking for two
my
buckets of
let's,
relief.
My
let's
bottom line
listen
is-
to,
I understand.
let's let Shannon reply to
but
that
let
first.
me finish up with a follow-up. But I would like, here's my bottom line. I understand some of this process and you don't know. Do I think we need to help with this situation because of this? I do. I don't think from what he does, and I know he does some amazing stuff as well. I hear about it from my people all the time. That if we can do something to help him, I'd be willing to do that. I am questioning some of your stuff, meaning on the process, and no, we're not the smartest people in the room sometimes. I'm gonna admit that myself on some of these process through government, sir. It's not just you, myself. I was on the tax deeds this year and I'm a commissioner, so, some of that stuff is just some of those processes, so, I don't think you're ignorant in any way, sir. I think some of us we learn from, doing and not always, yes, sir.
Okay.
So-
I want Shannon to be able to address first the address and notice. Do you have any comments on that?
Yeah, I do. So, Mr. Longfox says the address we had was the former office of the organization. And that address was used in title paperwork.
No,
No.
not. 628 and a half was used in the title work.
But
Three documents on it.
But the
And
address,
she's got a copy there if you want to see it. It's in the first sentence.
the address we had came from somewhere. We didn't make it up. The address we have for everybody is sourced from somewhere. That was an address of the property. He did say he came in with a change of address just this February. Yeah, so
When I knew you were sending it to the wrong place.
absolutely. And then we change it.
Could
but-
have this come,
22
Wait,
assessment.
wait,
okay, could have this come from the title company?
no.
I don't know where we got it, but like I said, it come from something. We didn't make it up.
Okay.
We will change an address and mail it to wherever the property owner wants, as long as we know what to. But in 2018, the very first tax bill,
Which attached.
there was a tax bill created
I will.
because there was no application for exemption then. There wouldn't even have been a tax bill then if there was an application for exemption then. And at any point in time, if we get an address change, we'll change it and mail it. We were too late to catch this year's assessment notice in
Can
February,
you tell them
Wait,
why?
wait.
Can you tell them why it was too late?
because we get those sent off to be printed before we got your change of address.
Your secretary told me that a third party does the addressing.
Absolutely.
Not your office.
Not the addressing,
A third party.
the printing. We mail a file to a company that prints and mails those, and that file was already sent by the time we got the change of
That's
address.
not what I'm arguing, is that
Okay.
it's not your office doing it, it's the third party determining the address. And state law says you're supposed to determine the address.
Okay, Bruce.
I'll shut up.
You're okay,
Thanks,
Bruce.
Bruce.
I also, because this is what I did not want to do, this is why
okay.
I wanted you to speak.
It's okay. Stand with me.
You're doing good,
You
Bruce.
do-
Bruce, you're doing good.
Travis
We're
has
not-
the,
we're not
Travis
scary,
has,
Bruce.
Travis
You're
has the
doing
floor
You're
next.
doing good.
I just have a couple of questions here. 'Cause I know about bulk mailing and I know about all that. So a couple of questions here, if you don't mind, Mr. Chair. So when do they have to get you notice of change of address? Is it March 1st? They have to let you know that they're gonna, the process. I just want to make sure that,
Somebody can bring in a change of address at any time throughout the year, and we change that address on the computer. And we did here, all right? We've got a current address for anything that'll be mailed from now on. But we got the change of address long past November 1st for the application deadline, and just after the time we started the process to mail notices.
that's my point. So you get the change of address after November 1st. You needed to have that change of address to mail it by November 1st. Is that what I'm understanding?
Yes, at any time through the year, we'll change the address, and then anything mailed after that point will go to wherever a property owner wants it to.
So then, let me ask this next question then. So obviously, they hadn't been at this 919 Main Street since what year?
2014.
Where's all those, see, we mail them off, are we not getting a return to sender that the individual is not there, they're not receiving the mail? Do we not get that from this particular piece? And I ask that because I get a lot of mail back when I mail it out and people have moved, so I'm just trying to.
So, sometimes we do, sometimes we don't. I don't know what the post office rules are, but even if we do, we don't know where else it should go. If I mail you an assessment notice and it's returned and whatever the post office says on it, I don't know where else to send it.
What, okay, maybe this is why my head is hurting. You're sending them a notice on a parcel that you know where the parcel's at. Do we not, if we get it returned, do we not then say, okay, if they're not here or they're not getting it, maybe we should send it to the land that we're actually gonna be taxing? Why is that not part of the process? And I'm just asking that question because you obviously want the tax money for that land.
The taxes still accrue.
They can be owned by somebody else.
There are thousands of properties where the assessment notice is mailed somewhere else.
Mr. Chair,
Commissioner Roskinek.
I'm just trying to get a grasp of what's going on here. If I understand it, in 2017, you purchased Lot B at Johnson Ranch from Hanny Chaffee.
Yes,
And then in 2018, you built the facility?
yes.
So in 2000, okay, so what we have to realize here is that the property address of Lot B is, I don't know what that address is, what street it's on.
South Valley Drive.
And normally so if you look at the property card, it'll say owner's address, property address, and so those are two different addresses. So the owner's address, if I understand it, would have been 628 and a half Sixth Street.
Correct, as filed with the Register
And
of Deeds.
so when you purchase that, you got a 180-day redemption, and then you got a warranty deed.
Correct.
So then there should have been some notice where Hanny wasn't going to get those assessments, and should have those assessments. Then that's when, to me, they should have started going to 628.
Correct.
But they were going to 919.
Right.
So that's, to me, this is where this whole thing
So,
started.
yeah, so South Dakota Codified Law 10-11-20, we cited to, before an assessment raises property taxes, they must provide proper notice at the residence or address. Exhibits attachments 1 through 3 show the deeds and deed paperwork filed with the Register of Deeds. Those list 6th Street. REI never filed an address with the Register of Deeds, the Treasurer's Office, or the Equalization Office that's a Main Street address. We never did that. This process starts with the filing of the deeds, which did list their address as 6th Street. South Dakota Law 10-3-31 places an affirmative duty on the Director of Equalization to examine conveyance documents.
Okay.
South Dakota Codified Law 10-3-32 places an obligation on the Register of Deeds to transmit the certified list of transfers of real estate, listing the addresses of the owners.
Oh, Chairman,
So we filed the correct address. Our argument is we never received an assessment of taxes. We never received anything properly addressed to the address of the property owner. This could have been corrected a lot sooner had we ever received that. When we saw the tax deed published through the banker, that's when Mr. Longfox went in and said, well, we need to change the address with you. We did make several inquiries to the Office of Equalization and try and figure out, how did you get a Main Street address? And they could not provide us an explanation.
Mr. Chair, my last statement would be this warranty deed, the identification of the property and the address of the owner, and that's 628 and a half
Yes.
Sixth Street.
And we were there until January of 2019. And then when we left, we did a 1-year forwarding service with the post office. So if the notices
Bruce,
had been sent
Bruce,
to the.
speak into the mic, lady in the, thank you, Bruce.
Sorry.
No, you're good, sir.
We left 628 and a half on January 2019, and we had 1 year of forwarding service from the post office at our new address of the 2112 South Valley Drive. So if proper notification had been made, it would have found us. We would have received it, and I at that point would have done an application for exemption. And so that's kind of what we're arguing is
Mr. Chair?
that state law requires that notice, and there was Shannon did not do his job as defined in state law. And then he's using the, laws against us.
So I guess my question is, we understand what's happened, but today you're asking for an exemption on the properties?
Yes.
That's what we're here today for?
Backward, and I know it's real unusual, but the impact on us, we paid $362,000 through 21, and now we owe another 120 for 22. That'll be 480,000, and that doesn't, like Rebecca said, that doesn't come from federal money. That comes from donations, and a lot of that money that I got, I bought copiers and put them out in the buildings and charged them to make copies. So it was nickel and diming it, some United Way money. But it's not like we're a rich organization that can afford $500,000. And so we know it's a big thing to be asking, but that's what we're asking.
Commissioner Hancock.
Forgiveness, basically.
So, Chairman, our bottom line is that, I believe, and Shannon, we've returned taxes before, were they exempt? Is there a clause, is there something that we can help where we can move these forward and maybe some of the taxes that were back? Because I remember us seeing, and maybe it wasn't what I'm thinking, that we've had it where people had exempt properties or they weren't supposed to be taxed the year before, that kind of thing. Whether the tax, for me, whether the tax deeds were sent to the wrong or the right or whatever, it's a process he's learning, number one. Number two, if he's telling you, he paid those taxes. He would have paid those taxes if he'd known and he'd got the proper notice. It's not like he had the taxes on his desk and he saw them and he just decided, Mr. Longfox, sorry, sir, decided not to pay them. So Shannon, is there something we can do to help? Because they are nonprofit. This is a lot of money. It's a lot of money for a nonprofit or otherwise. So is there anything we can do to back tax and give them some of their money back plus help them this year? That you have seen that this board can counteract this law or whatever on not filing by November 1st?
I don't think the board can counteract the law. But
Is there a clause or something?
so the law will allow an exempt entity to request an abatement for that portion of the previous year that they own the property. Okay, so does what you're thinking.
How many years back can you do
I know
that?
there's a limit, and I don't know, because I can't remember. But the property has to be exempt. And this year, it doesn't meet the requirements to be exempt. We don't have an application. So next year, the commission could act on it, grant the exemption, and then the property owner could request an abatement for the previous years that they own the property.
But you told me before, if I'm a nonprofit and I own property in my nonprofit, that I can call that property exempt because it's property owned and is used for basically my duties and responsibilities that I do in my nonprofit. So he was exempt. He's been exempt, and he bought property in 2017.
Never been exempt. It's been on the tax roll all these years. I said
The property has, but not you told me before, can't you do an abatement on something that someone owns that's exempt?
That is exempt.
Because they're exempt, and go back and abate them because that property should have been exempt.
The
back
property
then.
is
Just
not
because they didn't
exempt.
file, we've had Rapid City and other places that we've went back and abated because they didn't put exempt and we didn't know Rapid City owned property. We've done that. Why can't we do it with this property?
Because Rapid City doesn't have to make application for exemption. The law allows government-owned property to, by default, be exempt. There's no requirement for the city to apply for exemption, nor the county or the state or the federal government. This organization, I will say, would qualify under the statutes. They're a charitable organization or whatever. They will qualify, except for the fact that they didn't apply, and this year applied after the deadline. The commission has never approved them for exemption.
But do they have, sorry, Shannon, because they have reasonable cause why they haven't been put under there, they don't have that because of wrong addressing and different stuff? I don't know if it's your fault, their fault. I'm being straight. It's not that for me. It's because, number one, whether you sent it, they have reasonable cause that if it was put on their desk, that they would have paid those taxes and that they would have been exempt. But because they've never received the tax notice to them, not that they shouldn't have known that in one sense, but if you never went through the process, like if Mr. Longfox he owned the property before, and I'm like, Mr. Longfox, you've done this before. What's up with that? But he's saying in 2017, he actually got property. He wasn't leasing anymore, and there was a process, and he did not get the tax notices. I truly believe he didn't, because I believe if he's coming in saying, oh, 300,000, let alone a nonprofit not coming in and getting exempt status off a $107,000 property, that's unreal and it's unheard of. So he's telling you the truth. So how do we do that as a mistake, in a sense that they were sent to the wrong address? He's never done the process. Is there anything we can do for this as a mistake, or something else that we can help this nonprofit? Because I'm going to keep telling you, that's a lot of money. Even if we can't return all of it, if we can call them exempt this year or last year, whatever, just to do something in statute to help.
Mr. Chair,
Mr. Longfox.
Commissioner LaCroy.
you were before me.
Yes, sir. I was only just going to ask a simple question, and it is in line with what I think Deb is trying to get to. And my simple question is, if the board was interested in this, I was looking for wording for a motion of how we would do it, to say that we would allow them to have that application apply for this year. And then the follow-on to that would be, and this is kind of where she was going, if we do give them that opportunity to have the application apply for this year, and so that they can have that, what are we looking at for the abatement in the past? Because I expect that that's going to happen. What's the process? And I want to make sure that they understand it, and we know what that's going to look like for them as well. So those were my two things. I think it is appropriate. All the data that I went through here, I get it. Either maybe we need to look at our processes from the county, or from, if we're sitting in it somewhere and we know a property. I get it if it's a blank land and you're like, well, I can't really just go put a piece of paper out there and say, you haven't come in, so here, we're going to do this. But there was a structure built there several years ago, and if you're telling me you're going to make that structure pay back taxes, but you didn't try to even go to that structure and deliver some way, shape, or form, there's got to be a problem with our process. And I'm just saying, with the process itself, not an individual, but with the process. If we have a structure that we don't go and notify that structure that, hey, you owe taxes. I mean, we see that you've not paid taxes for several years, so here we're coming to let you know that you need to pay them. So that would be what I'm looking for guidance on, how to move forward with giving them the exemption, to allow them to have a late application for this year, and then work through the process for the abatements in the
Mr. Chair.
future.
But I'm next.
He was making sure that I went before him, so maybe I fixed some of
Commissioner
his
LaCroy.
questions.
I think the first step in this process, and I'm going to make a motion, is to get this going. So I would make a motion to approve the exemption request for 2022.
Second.
Got a motion and a second to give the exemption for 2022.
And I'd like the floor afterwards.
Okay, Commissioner LaCroy.
Thank you. I put that on, I wanted to get a motion on the floor to get us started, because I think if we get through this, then we can work our way back with an abatement or something in the future. But I think we need to get this. There's been some passionate testimony here today, and that's respectful. I'd be upset too. I mean, this is really unfortunate that this happened, and I think we all are going to learn from it. It's going to be tough to get the back stuff. You know, I'm not sure how that works. We're going to have to work through that. It may be next year. It may not be this year. But I think this board's passionate on working with you on that. They can not make no guarantees. This is government.
Shannon, tell us the process, or later, the process for requesting.
Let's take this motion first.
Oh, sorry.
One thing at a time.
So, okay, so any further comments on the motion that's on the floor? All those in favor of the motion indicate by saying aye.
Aye.
Aye. Opposed? Motion carried. Now we can talk about how we go back for an abatement.
Are we illegal on that motion, by the way?
Yes.
Figure.
No, I don't.
Wait, what
I
did
don't
you
think
ask?
I don't think that we are. I think as the Board of Equalization, we can do that.
Why would we be here if we could make that decision?
Yeah.
Because there's a law, but
Yeah,
that doesn't mean we followed the law.
that's right.
But, I mean, our position on it is, look, the statute says that the taxpayer has to apply by November 1st.
Well, I think that's immaterial at this point in time.
We agree.
No, I
think all of us
I think the question is immaterial, because
Okay.
we're accepting the one that was filed now on March 14th or whatever date that it was, as far as the Board of Equalization is setting. So now we talk about abatement of previous
Yes, sir.
ones. And, you know, I think Shannon's gonna tell us that if we try to do an abatement on that, that's illegal too. So,
I won't do that.
Okay.
I think you're illegal up to this point and then okay after that. So, what we've done in the past, and the law allows this, if an organization applies for an exemption and is approved, okay, and you just did that, they're there, they can then ask for an abatement for that part of the previous year that they own the property. Imagine an organization that purchases a property in January, okay? They can't apply for an exemption for that year because they have to apply by November 1st. They didn't even own it on November 1st. So they don't apply for that year, and there's a tax bill created. They apply the next year, and there is no tax bill, but they request an abatement for that part. In my example, it'd be all 12 months of the previous year. They request an abatement because they are an exempt entity. They have been approved as exempt, and the law allows them to request an abatement for the previous year that they owned and used the property in the same manner. So you can create you can grant an abatement for the previous years. There is a limit, and I don't remember what it is. I want to say 5 years, but I don't know. So then I ask you, do you want to do that now, or do you want to do it at a regular commission meeting later?
No, I think we want to do it now.
Yeah.
Yeah,
That's why I was wondering, that's why I asked the question. I'm not sure we can
Yeah,
abate.
Commission meeting.
Yeah.
It has to be.
I don't know if a Board of Equalization can do that, but I don't know why. So I don't care. I give you that question.
Mr. Chair.
Chairman, I'd say do
Yeah,
that.
I think the issue here really is that they didn't ever receive notice. According to them, they never received notice that they even owed taxes on the property. That notice was never received by them, by Mr. Long Fox, or anyone else that was connected with the daycare or the organization. And so I think that all has to be taken into perspective, going back to day one now. I don't think it's just, this last year.
So
Chairman.
I'm not gonna argue with you on that.
Right.
I don't think you should have granted the exemption this year, but I stated, I think they would, as long as they apply. Well, we do have an application for next year, they would qualify. But once they are exempt, absolutely, the law allows an abatement for the previous years.
So Chairman,
Okay,
my,
Commissioner Adcock.
my suggestion, because we don't do abatements here, we haven't never done abatements here, that we move it to a commission meeting. I don't know if that's the next one, Shannon.
And it might be easier to identify the number of years and the amount and do it later than try to do it now, because
Okay.
I think you're gonna ask me some questions that I don't know.
Right.
And it doesn't really matter whether we do it now or 6 months from now.
Well, the bottom line is it would be from 2017 when they were exempt up till now, right? Because you just said that now that they're exempt, we can go back.
Yes, but I think it's gonna be 2018's assessment.
Yes, because 2017, they don't get it till 2018. So you're right, sir.
Yeah, and it,
Included all those assessments in their packet from 17, 18, 19, 20, 21.
If the board
22.
wants to act on that, that's fine. I just don't have anything to present for an abatement.
so
No,
Mr. Chairman,
I think you bring it back to our regular
So
commission.
Mr. Longfox, so what's going to happen is we're going to have a commission meeting and then Shannon's going to look up, I think it's 18 because you wouldn't own the property till 18. You would have bought it in 17, bought, to pay taxes in 18. So it'd be 18, 19, and 20. And then 21 is we just tax exempted you, if I'm correct. So Shannon will tell us more of that information. So we won't do it here. You have to come to a commission meeting and Shannon can
Yeah, I've got it.
tell you when he's putting you on that commission meeting, or we can have one of our people as well.
So,
Makes sense?
it's the same people. Today, we're setting as a Board of Equalization, not as the county commission for Pennington County. And so that needs to be done at our county commission, at a county commission meeting.
you
So
have to
that's
speak
the
again?
reason that we have to do that.
I've got a question on, would abatement be the same process you would use to dispute that the assessment increases were valid? Because that's one of our bases, is to say, you have to by statute give us notice. When you're gonna increase the assessment, we have to receive notice. That's state law and you didn't do it.
Mr. Chair.
Would
Well-
that be
I don't
before
think
the
that would,
commission?
ma'am,
Let's do this.
that would move
That,
with this.
I think that's a legal question that if it goes the way I think that this board is thinking, that is a mute question at this point in time.
Yes.
Because I think in my opinion, as far as one commissioner, I think your abatement is going to probably be granted.
And Mr. Chairman, if I can point out, I believe we wouldn't be able to do that meeting, and Shannon, you can tell me if I'm wrong, until at least the first meeting in May, because we have to make sure that we finalize all this after the Board of completes, right?
I don't know. I would
We'll
say.
find out the specifics when the earliest we could consider.
I don't think so. I think we could do it anytime, but it doesn't matter. Because if the abatement is granted, it abates the entire year's worth. So that's why I say it doesn't matter if you do it next week or 6 months from now. The abatement takes care of the entire year's worth of taxes anyways.
He just like his money faster.
Well, except for that, yes, except for that.
And Mr. Chairman,
Commissioner,
I just thank you guys for coming here and bringing this forward, and I hope, it may not have been legal what we did, but it's taken the step forward to getting where we need to go. And as you just said, he needs some time to get all this together and moving forward, but I think the results are gonna
So
be what you need.
Bruce has to apply every year, right now?
Yep.
Okay,
Yes.
so Bruce,
Every year.
November 1st. Now you know the
Applications
process.
are available July 1st.
Yes,
right?
sir. Yes, sir.
Mr. Chair,
That's what that website.
Commissioner Roskinek.
I think so.
so let me get this clear. Nobody bought their tax certificate?
No.
Nobody,
Okay.
that I rushed as quick as I could.
They're lucky.
I borrowed the money and I ran down there.
Believe it or not, it happened to me because I didn't know I had it.
Actually,
Property, so
it was 358,000.
Here's a little more.
The treasurer had given me the amount to the end of February, and I paid February 18th. So. But yeah, that's what I was afraid of, is that would be a whole new complication that we didn't.
Need to
know how
get you
deal
closer to the microphone, Bruce, sorry.
that, you know, if somebody had bought that tax certificate, it would have caused even more problems, and so.
I know this
we
doesn't
were-
pertain,
we were
pertain to
lucky.
the issue at hand, but how's everything going out there relative to your operation?
Say again, I didn't hear you.
How's everything going relative to your operation out there with,
How's Head Start going?
Oh, Head Start is really in good shape because it's one of those programs that's not a political football. It's always given the money that we need. Our salaries are 20% below everybody, but that's the only issue. The Head Start is doing well. So, thank you, sir.
yeah.
Thank you.
We really appreciate the commission meeting. We appreciate the Office of Equalization. They've been good to communicate with to try and figure out how this all happened. But we'll look forward to seeing everyone at the commission meeting.
Okay, thank you.
Thank you.
You're not gonna adjourn, you're gonna continue.
Well, do you guys want
Right.
to take, do you want to vote on that, though? I know we have a first and a second.
Did
but
we
you
not?
didn't.
I have
No.
that we voted on.
Oh, you did?
No, I don't think we completed the
Uh-uh.
vote. I think you're right. We didn't complete it.
You didn't do all in favor.
All in favor of the motion indicate by saying aye.
All right.
Opposed? Motion carried.
Yeah, and then we just recess.
Can we recess?
Move to continue
Just recess.
our recess.
Second.
Okay, I've got a motion and a second to recess until 8:30 tomorrow morning. All those in favor indicate by saying aye.
Aye.
Opposed? Motion carried.